Top 10 Essay Topics About Contract Law. The concept of contract law. Contract law is the branch of jurisprudence that deals with developing, maintaining, and enforcing legal contracts and agreements. All businesses and consumers are involved in contract law to some extent. Business entities use contracts in the same way in their daily activities. In your essay, you can define contract law and describe its varieties and scope. Also, consider the importance of contract law in various areas of life. History of contract law. Contract law is a product of the development of culture and civilization. Before the advent of trade, other types of agreements were used instead of contracts, such as those based on kinship or religion. For the first time, contract law rapidly developed in ancient Rome. There were various types of agreements, some enforceable and others not. In your essay, you can consider the evolution of contract law throughout history. English contract law, history, and principles. The modern forms of English contract law are mostly a product of the Industrial Revolution and the previous century's social legislation. However, the foundations of European contract law, particularly English contract law, go back to ancient Greek and Roman legislation. In your essay, you can examine the fundamental principle of consideration in English contract law. Another idea is to trace the historical development and evolution of the doctrine. Valid contract, the elements. Contracts vary in complexity, focus, and timing. But there are several elements that should include enforceable agreements. These are legitimacy, offer, capacity, consideration, certainty, acceptance, and intention. We invite you to explore the critical components of a valid contract and highlight their significance in determining enforceability. Consideration in contract law. Consideration is a fundamental part of any contract aiming to ensure that the parties involved in the transaction receive something of value. This principle proves that the parties enter into an agreement voluntarily and with mutual understanding. We invite you to examine the concept of consideration, its role in contract law, and the exceptions to it. Contracts in the digital age. Modern technologies can provide encryption and secure storage of data. A digital contract is a legally binding agreement stored electronically. It has the same legal effect as a traditional paper contract. In your paper, you can discuss the validity of electronic contracts, including the use of electronic signatures and click-wrap agreements. Misrepresentation and fraud in contract law. Like any other area of business and jurisprudence, contract law is not free from deceit. In your paper, you can explore the misrepresentation and fraud in contracts. It would be a good idea to focus on the differences between the two concepts. Fraud is a deliberate act, and misrepresentation is sometimes done innocently. Compare these two concepts and add real-life examples. Business ethics and contract law. Contract ethics aims to ensure fairness and openness of contracts, as well as to protect the rights of the parties. How does ethical decision-making help parties involved in contracts? What is the broader impact on stakeholders, society, and the environment? These questions are worth discussing. Implied terms in contract law. The implied terms are not expressly stated in the contract. The appearance of such terms in the contract text is connected to the fact that the parties did not take them into account or did not think that a certain question would arise. In your essay, you could focus on the significance of implied terms in contracts. How do courts infer certain obligations to maintain fairness and efficacy? Real-life examples should also be included. The doctrine of frustration in contract law. The frustration doctrine works when an unforeseen event occurs that makes the execution of the contract impossible. An essential characteristic of a frustrating event is that it did not happen through the fault of one of the parties. In your paper, you can discuss the doctrine of frustration as an excuse for the parties from contractual obligations.